I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for another round of open government lessons. During this class, you'll learn about police misconduct records and how you can access them under your state's public records law. During this round of classes, we'll be joined by an attorney to explain how the law works, as well as a local journalist who will share their experience requesting these police records. If you haven't already, please view our previous classes on public records, open meetings, and state court systems. The lessons they provide are all cumulative, starting you off with the basics and then gradually addressing more nuanced areas of law and journalism practice. The classes are state-specific and provide practical, step-by-step lessons you won't find anywhere else. You can find them all in our FOI guide at NEFAC.org and on our YouTube channel, 5 Freedoms. Before we begin, I want to recognize the Estate of Gloria Negri for its support of these classes. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. Thank you also to the Rhode Island Foundation and the New England Society of News Editors for their continued support. And a big thanks to you for taking the time today to learn more about how to keep government open and accountable in your state. Now, here's NEFAC's Emily Sweeney to introduce you to today's instructors.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this latest round of lessons brought to you by the New England First Amendment Coalition. With us today is Dave Altamari. He's an investigative reporter for the CT Mirror, and his work focuses on government accountability, including financial oversight, abuse of power, corruption, safety monitoring, and compliance with law. We also have Dan Barrett. He's the American Civil Liberties Union of Connecticut's legal director. Dan and Dave, thank you so much for being here today.
Thanks for having us.
Yeah, and Dan, so I don't know if you want to start off and maybe talk about some of the legal aspects of accessing police misconduct records.
Sure. Yeah. So let's talk about the kind of sources of law that would get in your way of getting police records, because that's kind of most of the game here in Connecticut. So the important thing to start with, if you're interested in police records, is just to, ground yourself in the idea that police records are just public records in Connecticut. There's nothing special about them. The chances are what you're looking for is a public record. The only question is going to be, is there some obstacle in your way that's going to prevent you from getting them? And so when you're looking for information and you're being told, for example, that it's exempt because of a police records exemption, remember one thing, that the records have got to be both compiled in connection with the detection or investigation of crime, and they have to fit one of the exemptions. Now, there are 10 of them, which is awful. But that first one, compiled in connection with the detection or investigation of crime, is really important, because when we're talking about, for example, police misconduct, the chances are that if you're looking for police misconduct records, those are not compiled in connection with the detection or investigation of crime. Those are records that are put together for purposes of internal discipline, typically. And so unless there's a serious allegation and an actual investigation of an employee that is accused of a crime, chances are the police records exemptions won't even fit what you're talking about. So if you're looking for a disciplinary report, complaints against a police employee, those are probably not compiled in connection with detection or investigation of crime. So think about what you're asking for, zoom out and think, all right, is this really a police record? But if it is, in order to withhold it, it's got to fit within one of our exemptions. And I tried very hard to think of a kind of unifying theme to explain our exemptions, and I can't, other than there's kind of 3 buckets. The first is the ones that are enumerated in our open records statute as the police records exemption. For anybody who's super into the general statutes, this is section 1-210B3 is where they're listed. The other 2 that I'll talk about are kind of catch-alls that apply to a lot of other records, but they're frequently encountered when you're trying to get information about the police. So the first 8, the statutory ones that are in the Open Records Act. So you've got identity of informants and witnesses. If you're looking for stuff and the identity of informants or witnesses who are not otherwise known and who could be endangered by releasing the information is in there, that information could be redacted, which allows me to drop a footnote and say that just because a record that you're looking for or that's responsive to your request contains any of this stuff doesn't mean you don't get the whole record. What it should mean under our law is that the specific portion is redacted. So if there's a narrative by a cop that says, I was informed by so-and-so that X, Y, and Z, the name can be redacted. So think creatively and ask, oftentimes if I get a response that I can't have a whole record, I will ask for a blank version of the same record and then go through the fields and say, okay, so are you withholding the date? Are you withholding, the weather conditions, that kind of stuff? And you can really kind of narrow it down. But so here's the other of the 8 are the identity of minor witnesses, signed statements of witnesses, information that could be used in a prospective law enforcement action if it's prejudicial to such action. This is something that was touched upon by our state Supreme Court very recently in a case called Drum, D-R-U-M-M. And there the Supreme Court really shortened the leash for the police under B3D. In order to meet this, they have to show there's a reasonable probability that the information will be used in a law enforcement action. In that case, the cops had claimed because of this, in the case of this unsolved murder that had been kind of lying around for 20 years, that they could withhold under B3D because someday, somewhere, somehow, something could happen in that case causing them to actually prosecute somebody for the crime. The state Supreme Court said that's not good enough. You can't just do that. You have to show that it's a reasonable probability that it will occur. So if you get this back from a request who gets this objection, think carefully about what you're asking for, what's being claimed. Rounding out the other 8, we've got investigatory techniques not otherwise known to the general public. I've run into this occasionally. I think the key part of this is the not otherwise known to the general public. And the position I usually take and have been successful with in front of the Open Records Commission, the Freedom of Information Commission, is that if I can locate information about this, or I can see a video about it on YouTube, the chances of it not being otherwise known are slim to none. I say this because I asked Bridgeport some years ago for information about drones that they owned. And they claimed that drones were investigatory techniques, not otherwise known to the general public. That didn't go over well, but this is reserved for the sort of truly cutting edge stuff that no one really knows about, and that's a small list. Rounding out the list, you've got arrest records of a young person, a juvenile, someone under 18. You've got the name and address of victims of certain crimes. And then you've got this catch-all uncorroborated allegations subject to erasure. You may be aware that in Connecticut, a criminal charge that either doesn't end up being a charge or is taken to court and does not result in a conviction, the records of that automatically go away. And so you may run into uncorroborated allegations. It's a double-edged sword. It can be very helpful for people who are accused of things that they didn't do. On the other hand, it can be used if the cops simply decide not to prosecute, then all the records go away, and that can really hurt, especially when it comes to riding herd on the police themselves. But none of these things, I think you don't have to be a lawyer. Common sense would suggest that all of these things are things you might have thought of yourself as like, this may be withheld. But the key is if you get these objections, work through them and kind of think about what is it that's being withheld, and is it truly something that's not known to the general public? So going on, here's a little known exemption. This is not in our police records section of the Open Records Act, but this is the catch-all with the sting in its tail. And this is kind of like the post 9/11 catch-all security exemption, although it may predate 9/11. And this one has some real danger, because what it says is that any municipal police agency, it can withhold information for which there are reasonable grounds, and I've bolded some of the weasel words here, to believe that disclosure may result in a safety risk, including the risk of harm to any person, and that those reasonable grounds are determined not by the Freedom of Information Commission, but by the Commissioner of DESPI, that is to say the state police. So you don't need to show that there's no requirement that there is an actual risk, a probable risk, No need to show that there is a risk to a specific person, like a witness. It can be any person, and a safety risk, not a specific one, but a safety risk. And it's determined by the cops themselves. The reason this has a sting in its tail is that all the municipal police department has to do is call up DESPE and say, hey, we've got a request for these records. We'd like to withhold them under, could you certify under 210B19 that they can be withheld? And DESPE frequently does. I have a request in for every time that they've been asked to do this since I think 2018, and every denial they've given, and it's not clear to me they've ever denied it. So this one is really dangerous and maybe getting more so as the years go on, but just keep this in mind, that this is kind of a catch-all that applies to everything, not just police records, although it's used by the police the most. Lastly, I'd be remiss not to talk about body cam. I call it the body cam mirage. I hope that's not too provocative. People, I think, in Connecticut tend to think, oh yeah, we can get body cam. And that's kind of true. If you think about the body cam statute, though, which is 29-6D, it's got some significant loopholes. It was heavily worked by the police and their lobbyists. And so it's got some real pitfalls that you should be aware of. Sometimes it works fine, but sometimes it's a matter of grace. So body camera is purportedly a mandatory release item, but there's some fine print. The first is that the release may be delayed by up to 6 days. And so there are a number of hourly goals in the statute, should be released within X or Y, but the absolute end is 6 days. And there are a ton of loopholes. And I think I've done what you're not supposed to do with PowerPoint, which is this wall of text. But I kind of wanted to hammer the point home here that there's a lot of stuff that could be withheld under the body cam statute. That's not necessarily things that people know about. So communications between cops can be withheld. In fact, they're not even supposed to be recorded. This is an issue that if you cover cops or if you're really tuned into police oversight in Connecticut, you know has gotten a little bit of attention in that the municipal policies tend to allow all the employees to turn the cameras off when they're talking to other cops. Kind of a problem given that a lot of their job involves talking to their colleagues. Encounters with undercover police, informants, or detectives. Break time or personal activity, probably not that surprising and not that big of a deal for transparency. Anyone undergoing a medical procedure or anyone other than a suspect if they're inside a hospital, healthcare facility. You've also got any scene of an incident that involves a victim of domestic violence, a victim of homicide or suicide, or the dead victim of an accident. The first scene of an incident that involves a victim of homicide or suicide could be used, as you can imagine, to cover up when the cops commit homicide too. Finally, you've got the loophole for depictions of a minor. Now, of course, as with paper records, what this should mean for body cam is that stuff gets redacted or cut out. I don't think anyone's really interested in watching a police officer eat lunch on break. So cut that stuff out. Depictions of a minor, cut that stuff out or blur the face. It's in theory available, but you should be aware that there are these pitfalls that could come up if you're looking for these records. That's the rough lay of the land. We can talk more about it in the questions, but I don't want to cut into Dave's time because he's got actual exciting things to tell you about and like interesting stories, whereas I have statutes. So,
All right, that was great, Dan. Thank you so much. And now, Dave, we'll
Thanks, Emily.
see how you put this into practice.
Yeah, I'm going to go off script for a second. Something that Dan just mentioned, a little workaround. He talked about cases that where someone goes to court and they either plead no contest or they get accelerated rehabilitation. That case disappears. It's sealed. There is a workaround that I've discovered over the years. If you know the case and you know when they were in court, if you contact the court reporter, the hearing where they get accelerated rehabilitation, for example, is a public hearing, and you can get a transcript of the hearing from the court reporter if you know the judge and the date of the hearing. And I've done that a couple times in cases where the file disappeared, but since I know when they were going to be in court, I found the court reporter, asked her to pay, you have to pay for it because she has to go find the transcript and do it for you. But you can find the transcript of the hearing where it's just like a sentencing. The prosecutor will lay out their case before the judge accepts the AR or a no contest. So just a quick little tip there. A file may not disappear forever. There are ways around it. So I'm going to talk a little bit about one specific case. For years, I covered courts and cops in New Haven and Hartford. This was a case where 2 state troopers were arrested for basically beating a guy up. They got arrested for kidnapping was the initial charge. This case almost led to a massive change in FOI law in Connecticut if we hadn't fought it. What happened was these 2 guys were arrested, 2 troopers. They were off duty. They were at a party. One of the troopers felt some guy made some inappropriate remarks to his girlfriend. They basically cornered the guy, took him into the basement, and beat the crap out of him. They both got arrested, got charged. The major charge was kidnapping. So there were two things that happened with this case that we had to fight. First, when they went to court, the state's attorney tried to seal the arrest warrant, which doesn't happen as much now as it used to, but it still does occasionally happen. So we had to have our attorney go into court and argue with the judge to have the search warrant, have the arrest warrant unsealed. Then what happened is I knew that there were obviously an internal affairs investigation going on of these 2 guys. And while their case was pending, they were quietly fired. So I asked the state police for their internal affairs investigation report. One of the things to know about IA reports, if you're the subject of an IA report as an officer, you have to testify. You have to give an interview to the department under it's called the Garrity rule. So I knew that both of these guys had been interviewed about the incident as part of the IA. They were both fired. So when I filed an FOI for it, both the state's attorney and the defense attorneys went into criminal court and asked the criminal judge to seal the IA. The attorneys for the 2 troopers said that if it was released, it would be prejudicial to their case. The judge actually granted them that order. So we had to go to FOI because that would have been a terrible precedent to set. Every single police department in the state would have then just gone to a judge and say, "Judge, if you release this, it's prejudicial, seal it, please." So we had to fight at FOI to get her order, the judge's order, removed, and the files released. And the problem when you go to FOI, at least in Connecticut, as people may know, it takes forever. It's worse now than it was pre-COVID. This was pre-COVID. So this case, we filed the FOI in September. It took about 8 months, 9 months to get a ruling in our favor. And they ruled in our favor that this report was public. They did redact quite a bit from what some of the things Dan was mentioning from that they were able to redact that we certainly weren't going to fight, like the victim's name, the woman's name, because they said she was potentially a victim of a sexual assault. So we were more interested in just getting their statements. What did they tell the state police about what happened? So it took like 10 months to get those documents. We finally got them, and then right after we got them, both officers pled guilty and their cases went away. This is the actual decision, not much you can really read right here. One of them got 8 years. The other guy I think he got 3. but it was an important ruling because that could have changed one of the few ways that we have of figuring out what's going on with police, right? Every department, whether it's a small municipal department with 20 officers or it's the state police, has an internal affairs division. And those are all public, completed IAs are public documents. And so this would have certainly changed the way people would have been able to get those, because a criminal judge tried to step in where they honestly didn't belong. So that was one of the many FOI cases that we've done over the years, but it was one of the more important ones that we did, because it kept a very important part of police reporting an open record. I mean, I could talk about some other cases that I've done. You know, we spent 5 years fighting the state police for documents in the Sandy Hook shooting case. That was a case where a source had told me that the state police had quietly done a second search of the shooter's home a few days after the shooting, because the FBI profilers wanted all this stuff from the kids. They wanted his computer, they wanted all this stuff from the kid's room. And the state's attorney wouldn't give us the search warrant, or a copy of the search warrant, or the returns. Search warrants are public documents. They are filed. The state police or any police department has to go to court to get a judge to sign one. It's filed with the clerk of the court. They have to return it to the clerk of the court within 14 days, or ask for it to be sealed longer. In Connecticut, you can see when there are hearings to seal documents. They're on the judicial department website. If you look under media, you'll see something that'll give you a list of all court cases where they are trying to seal a document. Most of those are civil cases. They're trying to seal records, but occasionally you will see one pop up. New Britain police want to seal a search warrant, or that'll pop up on that website, on that site. I still occasionally look at it. You never know. A lot of the cases, frankly, it was a lot of priest cases back in the day that we had were sealed, that they would show up on that file. But so there are plenty of ways, certainly for court records, to keep an eye on in Connecticut on they're trying to seal. And if you see something that you don't think should be sealed, you can go to court and appear at that hearing and fight it. We have done that previously in some cases, in some civil cases. I did want to, the thing that Dan brought up, that there are ways around some of these things. Court reporters are good people to get to know. They're obviously there for any hearing, and most of them are pretty helpful. If you have an idea of when the hearing happened, which judge it was, they'll find the files for you. You do have to pay for them. It's their job. So, it takes them time to find it and then transcribe it for you. But I just got one relatively recently, a person that got AR, and I got the transcript of the hearing, and it laid the entire case out. I also got a couple of priests back in the days of the priests. I got a couple of cases that way as well.
Oh, that's really good to know, and a great tip. I actually was in touch with a court reporter working on a book about organized crime. And I got to say, just like you said, Dave, so helpful, emailing back and forth. I was like telling her about this transcript I was looking for that was like, from 25 years ago. But yeah, that's a really good piece of advice, getting to know court reporters. Dave, do you have a thought on the CSP's effective removal of records, communications associated with the Brian Mole death?
Good question. I've been wondering about that one myself. That report's never been made public. Just for everybody, that Brian Mole was a trooper. He was on on duty out in the Waterbury area. It was a bad storm one night, and his car literally got blown into a river, and he drowned. He died. And they have been very reluctant to release much about what happened that night. I got to tell you, in general, the FOI in Connecticut now is as worse as it's ever been, quite frankly. It's impossible to get documents out of the state without a fight or without, it's they, and I think they realize our FOI is so backed up right now that if you put in an FOI today, unless you have an attorney that's pushing your case, you're looking at well over a year before your case gets adjudicated. So they know, it's like they know, hey, you probably win at FOI, but so what? It'll be 18 months from now before I have to give you the documents. I actually haven't. I do know they haven't released the mall report. I never asked for it. I can't understand why that hasn't been fought. Well, that hasn't been taken up as an FOI. I mean, that's clearly whatever the final report is there, sure, it should be a public document. I don't see how they can withhold, there may be parts of it they can withhold, like, autopsies and things like that, but the actual, what happened to them should be a public document.
Yeah, so the person asking that question actually is Bridget Ruthman from the Republican American.
Oh,
And
yes.
And she
Oh,
said
very
that
well.
they have released it and it's heavily redacted. Thus they can withhold what they want. As we're all familiar with redacted documents. But yeah, Bridget, thank you so much for your question and for letting us know about that. Also, Dan and Dave, I want to let you know that one of our other audience members, Len Bestoff, said all your tips and comments are great. I'm listening as long as you're talking. So nice job. Okay, so Daniel Dunn was asking both of you, do either of you have any suggestions for getting a penalty enforced for violations of the FOI Act? That's a good question.
Sadly, no. The commission, I agree with Dave that the commission is the whole process is pretty bad right now. It's been bad for a long time, but it's real bad now. But the commission has really cut itself off the legs with a series of decisions in which it proclaims that it's very hard to issue penalties. And as a result, it almost never does. My own view is that if there's any hope of a penalty, it's to illustrate to the maximum extent possible the gamesmanship and bad faith that resulted in the withholding of the document and even the continued stalling in front of the commission. If a respondent shows up and makes a legal argument that's frivolous or that doesn't have any basis in the law, I think that can go to, or that should go to, whether or not there's a fine assessed. But there's a number of areas in which the commission has, for reasons I don't fully understand, sort of proclaimed that it has much less authority than it actually does. And penalties are one of those areas. Now, the commission did last year have a new kind of penalty provision put in place in the statute, but it requires such a pattern of intentional misbehavior that even the thickest public employee would understand how to get around it. So it's a teeny tiny half a baby step in the right direction, but as Dave points out, when the penalties are so few, there are no statutory deadlines. Public agencies they get the message loud and clear that they can just stall. So it's very hard, I'm afraid. I wish I had something better to tell you on that subject.
We had a case where the governor's office got slapped on the wrist. They had to, some of his people had to take a class on FOI. Big whoop. That's. Hey, Bridget, I'm thinking about your case. Have you checked the probate records on Brian Mall's case? If you're still on here, I would. You never know what gets filed in probate court. I'm sure he's got a probate case. He definitely had a family. Something to just trying to think of a way around what you're talking about. That might be one way to check what's in his probate file.
And I always, if you know, I'm always game to provide technical assistance to people with requests, even if you don't want to retain me as a lawyer, that's okay. You know, my interest, both as the ACLU's legal director and as a board member of NEFAC, is to make sure that we in Connecticut have that maximum access to records. And so if there are, from this report that you got, particular redactions that you want to talk over about whether or not they're proper, I'm always available for that.
It's great. Yeah, so hey, I want to thank everybody who tuned in for this. This was a really great discussion, with lots of great questions and lots of great tips and advice. Dan, Dave, I want to thank you so much for taking the time to do this. And yeah, until
My
next
pleasure.
time.
Thanks, Emily.
Good to see you both.